Good morning, everyone. We're Group 4, and today we'll be talking about Bill of Rights, which is from Section 18 to 22. So, each of our group mates will explain each section, so let's go.
As stated on the Bill of Rights, Article 3, Section 18.1, no person shall be detained solely by reason of his political beliefs and aspirations, meaning having different political beliefs and aspirations are acceptable under Section 18.1, and every citizen of the Philippines have the right to vote and support what or who they believe in, whether expressed privately or publicly, without being detained, because everyone has their own perspective of things. The Bill of Rights, Article 3, Section 18.1, is not limited to just political beliefs and aspirations. It also distinguishes the freedom of thought and the freedom to manifest political beliefs and, of course, aspirations. And it concerns the basic human rights and freedoms that belong to every Filipino. Having this written document, the Bill of Rights, it doesn't mean that you will discriminate against someone with different political beliefs and aspirations as you. It doesn't matter if the person doesn't mean to discriminate or whether they think they are being discriminatory or not. You should be responsible of your unlawful behavior as a proud Filipino.
According to Article 3, Section 18, no involuntary servitude in any kind shall exist except as a punishment for a crime whereof the party shall have been duly convicted. Ito ay nagsasaad na hindi pwedeng magparusa ng involuntaryong pagsisilbi kung hindi man ito ang kaparusahan sa kanyang krimen na ginawa.
In the Section 19 of Bill of Rights, it states that excessive fine shall not be imposed, nor cruel, degrading, or inhuman punishment inflicted. Neither shall death penalty be imposed unless for compelling reasons involving heinous crimes the Congress hereafter provides for it. Any death penalty already imposed shall be reduced to reclusion perpetua. Therefore, if any person has committed a crime, their punishment and exchange should be worthy and according to the crime that they have committed. For example, if a person is charged for being a drug dealer, therefore their punishment should be according to the laws that they have broken regarding drugs. But if a person is being charged for being a serial killer or by killing 3 or more people, therefore we would think that death penalty is a punishment that is worthy for them. But according to the Bill of Rights, Section 19, instead of a death penalty, they would be sentenced to life in prison.
Section 19. The employment of physical, psychological, or degrading punishment against any prisoner or detained, or the use of substandard or inadequate penal facilities under subhuman condition shall be dealt with by the law. Everyone has rights, whether you're a prisoner or an ordinary citizen. The use of any type of punishment on prisoner or detainees has a punishment that must be dealt with accordance with the law. For example, physical harm to them without sufficient reason, or any punishment that is inhumane or against our law.
Section 20, Bill of Rights. Section 20, no person shall be imprisoned for debt or non-payment of a poll tax. This means that the implementation of Section 20 of Bill of Rights grants the prohibition of imprisonment of a person that is not able to pay their debts or poll tax. However, creditors can still bring a debtor to the court to demand and enforce payment for their debts. Now, in addition, if the debtor issued checks to repay their debt, he will be subject to Batas Pambansa of 2022. The penalty at the discretion of court is imprisonment or a fine, or can be both.
Section 21 of the Bill of Rights. It states here that no person shall be twice put in jeopardy of punishment for the same offense. If an act is punished by a law and an ordinance, conviction or acquittal under either shall constitute a bar to another prosecution for the same act. Double jeopardy is a legal procedural offense that, in rare instances, prosecutorial and/or judge misconduct in the same jurisdiction. Prohibits an accused person from being tried on the same or similar accusations after an acquittal or conviction. It is most commonly employed in common law jurisdictions. In simpler terms, a person cannot be tried twice for the same offense based on the same behavior in nations that follow the double jeopardy law. Like, for example, a person who robs a bank is not eligible to be tried twice for the same crime.
The Bill of Rights Section 22 states that no ex post facto law or Bill of Attainder shall be enacted. The word ex post facto came from the Latin word that literally means retroactive, meaning that no law shall be retroactive or to take effect before the law was signed. In simple terms, an ex post facto law criminalizes the actions that were legal when committed before the law was approved. The Bill of Attainder, on the other hand, is an act where the law can inflict a punishment on a person without a trial. With the help of this section, the Congress cannot automatically convict and punish you without a trial, and they cannot also make you liable to the action, which is now a crime, you have committed before the law was passed because you were innocent that time.
In conclusion, sections 18 until 22 states that no person shall be punished or imprisoned because of their political beliefs, unpaid debt, or non-payment of poll tax, and by their actions that were previously legal before the law was passed, in any way that the party shall be convicted in any crime. A defendant should not be punished in any involuntary service or any degrading and unjust punishment that can endanger the defendant's life in any way possible. And that is our presentation for Group 4, Section 18 until 22. I hope you enjoyed it as much as we did. Thank you for watching.